Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena, which makes perfect sense that we had to do 215 shows before we did a program on pocket listing, whisper listings, off-MLS listings. Of course, in order to do a show so important, we had to bring back real estate attorney Roger Wintle. Roger.
Hi, Pat. Nice to see you again.
And, of course, the CEO of one of the best MLSs in the country, Jim Harrison. Jim, welcome.
Thank you. Appreciate being asked to be here.
The National Association of Realtors had their convention last November, and there was a 2-hour program. There's about 6,000 seats in a room. And 2 of the speakers were from California. We had the chief counsel from the California Association of Realtors, and of course your chairman, Robert Bailey,
right,
did a presentation, and then there was a fellow from back east.
Bill Lubin.
Okay, and that had about this issue, and it. Mr. Bailey spoke about how it's an epidemic. It started on the West Coast and went to the East Coast. Now we have a problem back east. Is that right?
It is. I mean, we've done a tremendous amount of analysis on this practice, this business practice. And so when we started talking to people about it from other MLSs around the country, everybody denied they had this problem until they looked into it. Then they realized that in every major city they have this problem right now.
Okay. Now, in terms of a pocket listing, Roger, we've had these terms before, and I understand the National Association of Realtors Code of Ethics, over 100 years old, and part of the problem was whisper listings. That's what they speak about, and they refer to them back east, that the realtors would get together, and if you had a home for sale or property for sale, you would put it on the exchange, the multiple listing service, and share it with your colleagues to get the most exposure. Can you speak about what a pocket listing means, or off MLS?
Well, by taking a property off the MLS, that means you're not exposing that property to the multitude of potential buyers who might see your listing, or
Okay.
whose agents might see the listing. I mean, part of the problem with pocket listings is it's similar to my business as a lawyer. Your foremost duty is to your client. You have a fiduciary duty, which is the highest duty imposed by law. Think about this. If you came to see me as an attorney and I would say to you, okay, Pat, I understand you have a legal problem. What's best for me? You'd get up and you'd leave.
Right.
And that's the problem with a pocket listing, because in my opinion, what's best for the potential seller is probably not having a pocket listing, which is basically not exposing it to the multitude of potential buyers, but that agent may have somebody that wants to buy this property who will offer a price that, well, we don't know what the price is going to be, because you really don't know the price until you put it on the market. You may say, I think it's worth $600,000, and you list it for $600,000, and then pretty soon you have multiple offers, and maybe it drives the price up, especially in a hot real estate market like today. Limited inventory, lots of people want houses. So that 600 may become 750. Well, if you sell it for 600 because your agent says that's what he thinks it's worth,
Right.
you never test the market.
Yeah, right.
So you've left $150,000 potentially on the table, or
That's
more.
Right. That's right. And that's a good point Roger's making, and you've done the stats on that behind the scenes, where you compared properties on the multiple listing service, and that's what agents, they have a property for sale, they put it on this exchange, the multiple listing service, and compared to the agents that have the listing, the home for sale in their pocket, that never gets exposed. What's the dollar difference on something like that?
Well, so the dollar difference is, the median price difference is about $100,000 better in price if you market it through the multiple listing service.
Okay, and that's in 5 counties.
We're in
and
5 counties.
And I understand, so in Santa Clara County, the delta was $105,750.
Right, it was even higher in San Mateo.
Wow, okay. So that, Roger's good point about exposing it to the marketplace. By the way, and people often say, It's about, well, I didn't want it on the market. We had, the seller wanted privacy because the seller, as an agent, we are obligated, aren't we, to put it on the multiple listing service?
Yeah, the service is a mandatory submission. When you join the service, you are committing to turn all your listings in the multiple listing service when you take them. And there's a process for a seller excluding their property off the MLS if they want to choose to do that. And there's a form involved in that. It's called an exclusion form. And the seller there's a lot of disclosures in that form. The seller has to initial several disclosure points and has to sign it. And the agent has to submit it to the multiple listing service. And I would just encourage sellers to think twice before signing those forms permanently on excluding properties from the MLS, because the size of the private market versus the market through the MLS system is so much smaller. And there's no way you can get the best price by selling it outside of the broad marketing tools that we provide to our subscribers.
Okay, so the program today is both not only for the consumers, the sellers, and perhaps the baby boomers helping their parents, the greatest generation, sell that property, but the agents. One of my mentors always said, agents don't know, some agents don't know they don't know, that this could result in some liability for the agent down the road.
Well, I think that there is a lot of exposure for an agent, even though there's a form that says you choose not to put it on the MLS. You know that when you go through a real estate transaction, there's a stack of papers. And if somebody that you trust says sign here,
They
an
sign
initial
there.
here,
They sign an initial
you
there.
initial and sign, whether you're told to initial and sign. I've had this problem in real estate litigation where somebody will say, I pick one piece of paper out of 100 pieces of paper and say, did you read this one? I don't recall. I had a judge once say, Roger, you know that no one reads every word in a real estate transaction. So you've got to be careful if you're a real estate agent putting something in front of somebody and not explaining to them that it might be better to put it on the MLS. But again, I get my example is, whose interest are we looking after here?
Sure.
If it's the agents, then you may want to say, you don't want people trooping through your house. Well, you could clearly do by appointment only
Right.
and cut down the traffic.
Absolutely.
And you could say you don't want people rifling through your house. Well, if it's by appointment only, your agent is probably going to accompany them. So you can get around all those privacy concerns. So you have to question why it's being done this way, because it doesn't make any sense to me why you would potentially leave money on the table by doing a pocket listing. But the agent has a couple of things that he has to be worried about. Number one, the California Bureau of Real Estate is going to hold that agent or broker to the standard that's predominant in the industry. And that's not really the industry standard at this point.
Is to hide the listing.
Correct.
From colleagues.
Then you've got the issue of, let's say the disgruntled seller. The seller sells it for the $600,000 price because you have a buyer that wants this house for $600,000. And he's so happy that he sold his property in 3 days that he goes and tells his neighbor, I sold my house for $600,000. And the neighbor says, well, Joe across the street just sold his for $750,000. It's the same size as your house.
Right.
Now you've got a disgruntled seller who's liable to go sue the broker and the agent for misrepresentation as to the price and not representing him in his best interest and breach of fiduciary duty, et cetera, et cetera. Now you've got mediation, arbitration, maybe binding arbitration or litigation over the fact that you're entering in territory that's risky at best. And so you're exposing yourself to a lot of potential legal liability and liability with the California Bureau of Real Estate.
Okay, so that reminds me, so there's the fiduciary duty, the legal duty to its seller, and then we have the industry duty to share with your colleagues.
Correct.
Right? And it goes even further, we have these private top 10% agents that are created these clubs a few years ago.
Right.
And they are sharing their own listing. I understand emails goes around saying, remember, do not share your home for sale on the MLS. And remember, the minimum brokerage fee is XYZ.
So I do know that at least in one of these private clubs, that they encourage their participants to be sure and exclude your property from the multiple listing service while you put it in our private network and expose it to just the small set of members of this private network.
Right.
And this one private network that's really based out of this part of the world has 1,600 members from 5 states. And in our private club, which is a subscriber only, but you just have to have a license to join,
Right.
we have 16,000 users in 5 counties, and we have reciprocal access to another 50,000 agents in Northern California, another 120,000 agents in Southern California. So if you really want your listings in the club that's going to get the most exposure, think about the multiple listing service, because there's lots of things you can do to control the exposure of that property, but still expose it to all the real estate professionals.
Okay. So we spoke about before the show, and this is what the point I'm using, Roger, is that in 2008, 2009, there was the multiple listing service at 18,000 properties for sale. And you didn't hear anything about this pocket listing or off-MLS. All the agents were doing open houses, broker tours, had signs, advertising. They were actually stopping each other and saying, do you have a buyer for my 4-bedroom house with Brown and Kaufman, with Cupertino schools? I mean, there's a lot of that going on. All of a sudden, the inventory shrinks to the lowest level of my career, and we have this spiking. This now, it was 10%, 15%, now 20% of the listings are pocket listings where the agent, the listing agent, seller's agent is hiding it from everybody else. So now part of that problem is not only the greed factor, but now the seller hired an agent to represent him. Now that seller, that agent is now representing the buyer in what's called dual agency. Can you explain what dual agency is about?
Well, dual agency is when the brokerage company or the agent represents both the seller and the buyer. And think about this. If I were in a lawsuit, I'm going to put on my turf, and then I'll answer it in a real estate standpoint. I'm representing both of you in the same lawsuit, and you have diverse interests.
Right.
How can I do that? I could have you sign a waiver that says,
it's okay.
I'm telling you that it's okay. But is it okay? No, I don't think it is. And I have trouble with dual agency. California is one of the few states that allows dual agency. You want to sell your house at the highest price you can possibly get. Jim wants to buy your house, but he wants to pay the lowest price. So how as an agent do you juggle those so that you're doing your fiduciary duty to the seller and you're doing your fiduciary duty to the buyer? It's difficult. One of the things you mentioned that I also want to talk about is this idea of forming clubs. You know, there's all kinds of anti-discrimination laws, federal and state. What are these clubs for? I mean, why are they being formed? What's the purpose? Is it to exclude others? Because you have to qualify in some way, shape, or form, I would assume. That's probably not before the courts yet, but it could be.
Right, exactly. Now, speaking of that dual agency, I know you've done the statistics, how many are coming, listings are off MLS and on MLS. Now, traditionally, if it's a pocket listing, it's being sold by that firm. And Roger just mentioned that's a dual agency situation.
Well, so as we're looking at our stats and trying to measure what looks like pre-marketing before property's put in the MLS, it's the double-ended deals are growing as inventory continues to decline. When I say double-ended, I mean that the agent, one agent is both the buyer agent and the seller agent within the same company.
Okay, wearing the same hat. So this is for the audience and the lay people and the baby boomers and the greatest generation, that when having your realtor, your agent represent the buyer is problematic at best. Now, the other issue is that, and Roger, you've been on the show many times, we've talked about dual agency. We've talked about the seller is often the target. When I speak with real estate attorneys in California, they say 80 to 90% of the claims, it's a buyer going after the big bad seller, right? So dual agency just takes that to another level.
You got the big bullseye on your chest when you're a dual agent, because most of those cases are the buyer suing the seller either for non-disclosure. I've got a case right now, and it's clear to me that the listing agent and the seller knew about an issue and
Uh-oh.
didn't disclose it.
Uh-oh.
It's a dual agency situation. Now, the agent's going to have a problem because he's representing both sides of the coin here. The buyer's mad at him, the buyer's mad at the seller for non-disclosure, and now he's got to deal with that. And you don't have an arm's length transaction, theoretically, even though California allows it, it is legal to represent both sides of the transaction. I really don't think it's healthy for the real estate business to do that, because I think it puts real estate agents and brokers in a bad light when they're representing both the buyer and the seller, because if somebody becomes unhappy, they're liable to be unhappy with the seller.
Exactly.
And they're going to sue the seller, and then they're going to look at the agent next, because the agent and the broker have E&O insurance. They have insurance that can pay a claim. And so a lot of times they get dragged in, rightly or wrongly. But as soon as you see that dual agency in the transaction, as an attorney, my antennas go up, and I'd say, this is a possibility that this agent or broker has to be brought in to a lawsuit.
Okay, and the E&O insurance stands for?
Errors and omissions. Every broker should have, like every attorney should have, errors and omissions insurance. What that means is, if you make a mistake, and let's face it, we all make mistakes, then your insurance will cover it. Insurance does not cover deliberate fraud, criminal acts. Anything that you do that's deliberate is not going to be covered by insurance. But if you make a mistake, you forgot to initial something, you forgot to do something, and it results in potential liability or a lawsuit, then your insurance will cover it.
Okay. Now, this is a good point, because the sellers, Jim, are the target in most of the litigation in California. And the buyers, real estate attorneys always say that buyers will have a claim that's with real or imagined problems, and they're going after the seller. Now, it's a lot better for the seller if the buyer had their own buyer's agent and a separate firm and separate E&O insurance, right? A little insulation there. But in this dual agency situation, this pocket listing is twice the problem for a seller, and it's not really being described, because the seller is leaving a stack of money on the kitchen table behind. In addition, when they think they're driving off into the sunset, if that buyer has real or imagined problems, they can drag them back into some litigation. Now, let's look at some of the numbers here. In 2013, well, this 2011, there's $2.5 billion of real estate off the MLS.
Correct.
Okay, 2012, $3.4 billion of residential real estate. In 2013, $4.8 billion off the MLS.
Yeah, those are transactions that happened outside of the MLS. So we came up with those numbers by analyzing county records compared to transactions in the multiple listing service.
Pretty simple to do. Now, in course of the growing pocket listings, we had 11% in 2011, 14.5% in 2012, and 2013 is over 20%.
Right.
Okay, so I think at the National Association of Realtors, the lead counsel mentioned that she felt there was going to be a wave of litigation. Now, that's typically after something, a certain phenomenon happens in a real estate market. The litigation's a year or two later.
That oftentimes is the case, and what you'll probably have is, again, and you've got a double whammy here, because you're doing the pocket listing and not exposing it to the general public. But you're also in the middle of a rapidly increasing and escalating real estate market from a price standpoint. So what's today is $100,000, maybe $150,000 in 3 weeks, depending on demand. So you automatically increase your exposure, because let's assume that the agent who did the pocket listing did an appraisal, covered himself as best he could, did everything by the book to try to protect his client. His fiduciary duty was to the client, and he met that duty. So the seller sells it at the height of the market, $700,000, and that's the market. And next month it's $750,000. And do you think that seller is going to say, I left money on the table, and it's all your fault because you represented both sides?
Right.
And you did this pocket listing, and you didn't put it on the MLS, and I didn't get multiple offers, and everybody says I should have gotten multiple offers in this market. you're asking for trouble.
Okay. Now let's speak about that form, because the lead counsel mentioned at the National Association of Realtors this exclusion. The seller has to refuse to put their property on the multiple listing service. Those are her exact words. And so to have a seller refuse to put their property on the multiple listing service, there should be a conversation taking place about the pros and cons. And it was her view that that's probably not taking place. A conversation of pros and cons.
Yeah, I started out this conversation by saying you have documents. If you trust your agent, and your agent says sign here and initial here, oh, this is just the listing agreement. You don't want to put it on the MLS. Remember, we had that conversation, or doesn't even have that conversation.
Sure.
And then later, the agent in a litigation says, well, you signed this piece of paper, and the attorney on the other says, well, how many other pieces of paper did this individual sign? What information did you give him before he signed this? Did you follow it up with an email? Because that may be the most important piece of paper in that file for the broker or agent standpoint. Did you send him a separate email? We had this discussion. Here's what I told you. Here's what you told me, and then I gave you the file, the piece of paper to sign. Do you think most people are doing this? Probably not.
Probably not.
And so you have a piece of paper that says if you don't list it on the MLS, you may be you may not be exposing it to all the potential buyers who may be interested in your house. I don't know what the exact verbiage is. It's probably something very similar to that. But if you don't explain it to them, especially if somebody doesn't understand what the MLS is, I mean, that's not an everyday knowledge for most people what the MLS is. I mean, they go on and maybe shop on the internet themselves and look for houses if they're thinking about moving, or their kids need a house or something like that. But most people don't know how it works.
Well, no, I know that, Jim, you've written several articles that have appeared in the major newspapers.
We've published articles. Mercury News has picked them up, and several other Bay Area newspapers have picked up our articles.
Because Roger makes a good point. People really don't understand how it works. They only buy or sell a house maybe every 40 years or every 7 or 12 years. And in fact, the president of the California Association of Realtors last year was very vocal on this issue as well.
Yeah, California did webinars. They published articles. I think there needs to be a whole lot more promotion to the public about the benefit of having your agent use the multiple listing service to help you market your properties, get your best price possible.
And this is also helping people, of course, with the prices coming back up. They're not underwater as we had in the past. But for the senior citizens or baby boomers retiring, leaving $100,000 on the table is problematic.
Yes, 10 years in a facility.
Exactly, $1,000 a month. Now, Roger, in terms of the firm, can you describe for us again dual agency? We have the in-office. Now, if there's a firm that has 1,100 agents in 10 offices, and there's a firm in Milpitas and one in Palo Alto, that's still dual agency, correct?
Absolutely. Absolutely.
Okay.
The most egregious situation is when it's the same person in the same office. But you could have some of these real estate agencies are really large, and they'll have offices in multiple locations. But it's still a dual agency because you're still under the auspices of that real estate company.
Now I know in offices, because I was in big offices, and they have weekly sales meetings. And they have a section called wants and needs, and an agent will say, I have a buyer that needs a 4-bedroom house, Brown and Coffin with Cupertino schools. Another will say, I need a townhouse in Piedmont with a Piedmont elementary, and so on. Then in the next week, a realtor will say, or an agent, I have one of the townhouse coming up with a Piedmont elementary school. And all of a sudden, we have this marriage inside the office. So even though that's taken place now, that sale might happen with not go on the market, not go on the MLS. However, it's probably best for the seller and best for the firm and best for the agent if they still put a sign on the lawn, put it on the broker tour, put it on the MLS, correct?
Oh, absolutely.
Right.
Because from the real estate broker and agent standpoint, you've got to protect yourself. And we have a litigious society. California is notorious for lawsuits. People will sue for the darndest things, and a lot of people come in and talk to me about lawsuits. I spend most of my time trying to talk them out of lawsuits.
Right.
But there are a lot of people in my business who will take a lawsuit on, even though they don't have any real feeling about whether they're going to win or lose, and they just figure if you can pay, I'll take the money. We'll see what happens. It's the same with a real estate broker and agent. Your primary duty, again, and I'm sounding like a broken record here, is your fiduciary duty to your client. And if you're an agent, you also have a duty to your broker to use your utmost care.
Absolutely.
Because that broker is going to be hauled into a lawsuit potentially. I've had numerous cases where the broker had no idea what the agent was doing. They were really off the reservation, but it doesn't make any difference because from the California Bureau of Real Estate standpoint, you have complete control over that agent regardless of what they're doing. They won't take the answer that if they're doing something and you don't know about it, then you're absolved from liability. Why don't you know about it? Why didn't you know about it is the answer I always get. And so you're talking about meetings. I've had a number of brokers that I've represented over the years, and they don't manage their agents very well, and they don't have regular meetings to impart this information, and I think they really should.
And that's that failure to supervise
Absolutely.
where the brokers get into trouble.
That's where they're always going to get you, is the failure to supervise.
And I think, Jim, you've reached out to the brokerages, to these office managers as well, to let them know there's a situation.
We have, and don't find many brokers that are in favor of this type of business practice, actually, because it creates risk for their companies.
And I know you've been very proactive, and you're speaking to a board of a breakfast meeting of Realtors tomorrow morning.
Right.
Okay, so we're trying to get the word out. So if you are a seller and you have a property for sale, Roger, they need to put a sign on the lawn and get that maximum exposure?
Absolutely, and get it on the MLS.
Okay.
There are plenty of buyers out there.
Now, let's just let the realtors know, the agents know, if they do get into litigation, it could last a year or two and $5,000, $10,000, $15,000 in defense costs.
Well, that's pretty low, really.
Those
You have to worry. The agent has to worry about their deductible under their E&O policy, and then the E&O policy will kick in after the $5,000 deductible or $10,000 deductible. But for most real estate agents, the biggest problem is they have to deal with the legal system.
They have to deal with the legal
You're
system.
not out there beating the bushes to get a listing.
Right.
You're not out there showing property. You're talking to me.
You're
Or
sweating,
you're talking to the judge.
and you're sweating out these depositions. I want to thank you both for joining. And I know the Fields case of George, the judge mentioned that the agent has to put himself in the shoes of the principal.
Absolutely.
Okay. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. So sellers out there, if you hear about a pocket listing, off-MLS listing, or having your agent represent the buyer, think twice. Thanks again.